crimes. So they're tasked with this. This isn't something that they have to act on as a guaranteed outcome to move forward on a case in the first place. So it doesn't have to be a guarantee of a conviction for a DA to bring charges. DAs can influence state policy by using their bully pulpit. So what that is their influence. Again, the highest paid state elected official has an opinion that is going to be valued by the governor, it's going to be valued by the mayor, it's going to be valued by the chief of police, the manager of safety. And that's something that we have to recognize. You have the ability to voice your opinion in many areas of the work that many of us are focused on. So the DA can also provide services to crime survivors, people who, and that whole framework, what that's supposed to mean and what that looks like. People who are normally recognized as survivors of crime are not people who are normally victimized by criminal actions. For example, folks coming out of the penitentiary or people who have been victimized by law enforcement are ineligible. They're not seen as victims, and they would be ineligible for any support coming out of the district attorney's office as crime survivors. So that is also part of the language we are trying to set moving forward, that this office has discretion that can be used in the very nature of who's identified as a crime survivor in the first place. And the DA's office can and does lobby, and this is very, very important. The DA's office, the Colorado DA's Council has a lobby group that lobbies up at the Capitol to create new crimes, to create mandatory minimums, to create plea bargain agreements, to strengthen the office, and all of this happens behind closed doors. So things that we need to pay attention to as community members are ways that the lobbyists are exercising their power to strengthen this office. Next slide. No, please go ahead.
Next slide. Awesome. So we've been talking a lot about prosecutorial discretion, and it's probably one of the most important responsibilities that DAs have, is that they have discretion, which means it's up to each individual prosecutor and attorney to interpret the law based on the case and the facts that's in front of them. I'm just going to read the definition really quickly, if that's okay. But it's deciding whether or not to file criminal charges based on the discretion, the motivation, and the interpretation of the laws by the attorneys assigned to the case.
Right, so this is an absolutely crucial way that the DA can use their decision-making power to influence our communities. There's a perfect example. It's not perfect, but it shows the problems when they use their discretion against us. So there is a young woman named Shani who is a DPS student who recently has been charged with a crime. There was an incident. She was basically being argumentative or defiant to her teacher, and the principal was called in, and they basically asked Shani to leave the classroom. Shani excused herself, went to the bathroom, and the principal and a security officer for the school, because we have police officers in the schools, followed her into the bathroom, the ladies' bathroom, and basically removed her from the bathroom, and they brought her back outside, and there's video of this whole thing, but Shani was charged by that officer with assault on an officer, which is a very serious crime. It's a felony. It carries serious penalties, and Shani is, 17? She's very young. She's 15, even younger. And since then, there has been a lot of unrest about her case because she clearly didn't assault this officer. There's video that hasn't been released by the school that shows that she didn't do that. The DPS has even come out and said publicly that the officer was in the wrong, not Shani, and that this officer shouldn't have touched her and handled her the way that he did. But still, Shani continues to face the charge of assaulting an officer. This is something that District Attorney Mitch Morrissey could, if he wanted to use his prosecutorial discretion, to decide that there's enough kind of issues with charging a 15-year-old with this serious of a crime in an incident like this, where she clearly didn't, seek even, if I just simply brush Cecilia's shoulder, that's technically assault. So there's a wide-ranging kind of charge that you can apply, and it's very clear, especially with the DPS school, saying that the officer was in the wrong, that Mitch Morrissey should use, the DA, should use his prosecutorial discretion to throw Shawnee's charges out. That has not happened, and that's a huge part of what we mean about having DAs who are accountable to our communities, who are working for us instead of against us, as in this case. So we wanted to take the moment for this side note to suggest that if people are available on Friday, April 15th, what time is it, do you remember? 9 o'clock a.m., thank you. So if you're available on Friday at 9 a.m., Shawnee and her family have been asking for people to come support them and show the court and the judge that there's a lot of support behind Shawnee, and that the judge should also use his discretion to make sure that Shawnee doesn't face the consequences of this stupid charge. So they have asked everyone to join them at Friday, April 15th at 9 a.m. in the Lindsay Flanagan Courthouse, and that's going to be in room 2H. So if you can go and support, it's going to be just come observe, come show your support for Shawnee, and that will be something that will be great. What's up?
Can you just let them know also that they are trying to charge her with felony?
Right, yeah, and that's the seriousness of assaulting an officer. It's a felony that carries a serious prison sentence, and it would really set Shawnee's life back in a serious way. And it's the sort of thing, just this kind of case, and on an everyday basis, the district attorney can choose to basically screw you or make it a lot easier for you to learn from your mistakes and continue on with your life, which is a huge part of what prosecutorial discretion is about. So some other things about the decision-making power that the DA has. The DA, one of the biggest parts of contributing to mass incarceration that the DA does is the plea bargaining system. District attorneys are basically empowered to negotiate with lawyers who are defending defendants like us who might have been accused of committing a crime, and they will play this kind of backroom negotiation game before the trial actually happens to basically say to a defendant like me, well, there's this very serious incident and there are 7 felonies that I could charge you with. And all of those 7 felonies together carry a sentence of over 200 years and fines of over $3 million. But I'm going to make a deal with you. I will use my plea bargaining power to simply charge you with 1 felony, but you have to plead guilty right now. The next time you show up in court, you must plead guilty, and you can take the whatever charge that I give you and go with that one, or you can go to trial for all 7 cases, all 7 felonies, and hope that you are cleared of every single one of them. This kind of leverage is the way that district attorneys across the country intimidate and leverage their power, their discretion, to make it so that we feel like we have to plead guilty. Case in point, in the American criminal justice system, over 95% of trials, of charges that are filed against citizens are settled as guilty pleas. Let me say that again. 95% of the kinds of charges that show up in American criminal justice system are pled guilty to. And it is because of plea bargaining. It's because district attorneys have so much power that they can basically make it impossible for you. They can make you deals that you can't say no to. And this kind of plea bargaining and the 95% conviction rate is exactly one of the biggest contributors to mass incarceration that this country has. The power of district attorneys to basically make it impossible for you to get accused of a crime and not end up pleading guilty is a huge part of why we have over 2 million people incarcerated in this country at the highest rate of any civilization in human history. So plea bargaining is a huge thing that we need to make sure that our district attorneys are accountable and have come out and said, even before we elect them, that they are not going to abuse this kind of power. We can say a lot more, but we can also cover that later. So another part of decision-making power is mandatory minimums. Basically, these are laws that say that if you're charged with any kind of with a specific kind of crime, there's a mandatory, you have to be sentenced. And in lots of cases, district attorneys, again, can choose to charge you with a crime that actually has a mandatory minimum, or they can just ignore those things and make it so that you can, again, continue to recognize your mistake, be accountable for it, but not have your life ruined.
Just to add to that too, mandatory minimums. What that is doing is it's taking power away from the judge. and it gives it to the DA's office. If you take a case all the way through trial and it carries a mandatory minimum, there's nothing the judge can do. His hands are tied. You have to write out whatever sentence is attached with that mandatory minimum. And that is beneficial for the DA's office. And that goes directly in conjunction with plea bargaining.
Right. That's a huge part of it, is that, you know, the higher the rate of convictions that a district attorney can secure in their tenure in whatever office they're holding, or any kind of attorney, it's good for their resume, right? It like makes them look like a better prosecutor, and they gain status and continue to advance through the ranks. And that's a huge part of why the incentive system around plea bargaining mandatory minimums is so messed up and hurts us as a community ultimately. The last couple ways that the district attorney can use their discretion and use decision-making power to influence things is to decide who is and isn't eligible for diversions, which are basically ways to not be convicted of crimes, things that you could do in a case like Shawnee's, but have recognized basically that you are committing to changing and sort of holding you accountable to changing. We'll cover more of that in the next slide, so I don't want to say too much. But then they also, district attorneys can decide whether or not the state seeks the death penalty. This is a very serious kind of decision-making power that we empower this elected official to exercise over our community, the choice of whether or not to try to kill someone for the crime that they committed, not to be taken lightly. And the last thing is about the services that Cecilia talked about. Victim services and the kinds of funds that the district attorney is allowed to manage, they can use the decision-making power to decide about which victims of crime are compensated, get these kinds of funds and services that are and are made accessible, or shrink the pot of the group of people who are able to access those kinds of services. So there's tons and tons of ways that the district attorney can use the decision-making power, and they are accountable to us. And so again, we're going to continue to drive home why it's so important to hold them accountable and really know who we're electing. Next slide, please.
So one thing that we thought was important was having a clear distinction on what the differences between diversion and a deferred judgment are. And so we were like, you know, one thing that we also want to highlight is that we're not attorneys. We are learning in this process, and we need references sometimes ourselves. But a diversion program is a criminal justice system, is a form of sentencing designed to eligible offenders. And again, this is the discretion of the district attorney of criminal law to avoid criminal charges. So in a sense, it's hanging over your head. And upon completion of this program, the charge could be waived, or upon failure of this program, you may follow through with sentencing and whatever consequences follow. Such programs are often run by a police department, court, district attorney's office, or outside agency, an agency that would be approved by the district attorney's office. But one thing that does offer is outside community-based resources as possibilities for diversion programs, mental health resources, addiction resources, etc. So. And then a deferred judgment. A deferred judgment allows a judge to withhold finding a defendant guilty and place the defendant on probation for a period of time. The judge may place a number of conditions on that probation. So again, these are just things to keep in mind, know these definitions when you're navigating any part of the criminal justice system. Yes?
Something you said something about the district attorney being accountable to us, but as I've seen and since I've lived here, I haven't